Learning how to co-parent with an out-of-state parent can seem daunting. This is especially the case when you're in Oklahoma and your co-parent lives elsewhere. It's an issue that requires not just a good understanding of the law, but also a strong commitment to effective communication and cooperation for the sake of your child. Oklahoma's family laws are designed to safeguard your child's best interests. When making any decisions about custody and visitation, it's important that these choices benefit your child's overall well-being and stability. Remember, your child's needs come first, always. Often, a court has to make the determination of where the child will reside, but takes into account an agreement made between parties. The court is likely to side with what is stable for the child. This could mean the parent moving out of state will likely have to travel to Oklahoma a lot, or pay for the child to visit them. When navigating how to co-parent across state lines, the importance of communication cannot be overstated. Regular, honest, and respectful dialogue about your child's needs and schedules is vital. Nowadays, staying connected is easier than ever. Use emails, text messages, and video calls to keep the lines of communication open. This not only helps in coordinating schedules, but also shows your child that both parents have active involvement and are caring, despite the physical distance. No parent wants to feel voiceless when it comes to their child's life. As parents, you should jointly make significant decisions impacting your child's life, be it about their education, healthcare, or religious upbringing. Keeping each other in the loop and respecting each other's opinions is vital for reaching consensus or compromise. Ultimately, a reasonable and amicable co-parenting relationship is achieved through the mutual love for the child. Creating a visitation schedule that suits everyone, especially your child, can be tricky. You might need to plan for longer visits during school holidays or special arrangements for significant occasions. Oklahoma laws offer flexibility in this regard, allowing you to tailor a plan that best suits your family's situation. Just ensure that your agreement is documented and, if needed, legally approved to avoid future misunderstandings. Figuring out the logistics of your child's travel between states for visitation is another important aspect. You'll need to consider the costs, timing, and modes of transportation involved. Ideally, these responsibilities and costs would be shared between both parents. However, in the scenario that you are the relocating parent, you should plan to foot most of the cost of travel for the child or yourself. It is unlikely that a court would order the parent staying in Oklahoma to pay for the travel. An exception that could happen is an order for alimony that you could theoretically use for your travel expenses. Clearly defining financial responsibilities, including day-to-day expenses and additional costs like travel for visitation, is important. Oklahoma's child support laws ensure that both parents contribute to their child's upbringing. The amount is based on each parent's income, the number of children, and other relevant factors. A parent making the most money will likely have to pay the most, but if a parent makes no money, they will be imputed at minimum wage. When learning how to co-parent with an out-of-state parent, it's very important to have people in your corner. Without a support system, you're more likely to have stressors that impact your abilities to co-parent effectively. Relocation is a common scenario in co-parenting dynamics. In Oklahoma, it involves specific legal steps, especially for moves over 75 miles. If you're the custodial parent planning to relocate, you must notify the non-custodial parent in writing, ideally 60 days before the move. This notice should include the new address, the reason for moving, a proposed visitation schedule, and a reminder of the 30-day period for the other parent to object. If the non-custodial parent objects, a court hearing will decide if the move is in your child's best interests. The court will consider factors like the reasons for the move, its impact on your child, and the feasibility of maintaining a relationship with the non-relocating parent. For non-relocating parents, if you oppose the move, you'll need to demonstrate why it's not in your child's best interest, possibly leading to a reassessment of custody and visitation arrangements. If you can provide proof you can maintain stability for the child more than the co-parent, the court is more likely to favor that.